Welcome to the tutorial on business ethics. Today the chapter is ethical decision making, employer responsibilities and employee rights. I'd like to start this tutorial with a quote from the Franklin D. Roosevelt. The summary of the quote is that the best customer is the well-paid worker. That means if one company focuses on the workers' health and safety and other issues, the company will be benefited in various ways. However, ethics in the employment context is perhaps the most universal topic in business ethics because nearly every person will have the experience of being employed or employing someone else. That means most of the people in this world, maybe they are employee or they are the employer. Ethics at work and in human resource management is about our relationships with others and with our organizations. Research demonstrates that companies that place employees at the core of their strategies produce higher long-term returns to shareholders than do industry peers more than double. That means any company that care its employees will produce higher profit due to productivity and higher profitability. The two distinct perspectives on the ethics of workplace relationships. That means if we consider the workplace relationships, there are two distinct perspectives. The first perspective is employers might decide to treat employees well as a means to produce greater workplace harmony and productivity and higher levels of innovation. That means employers may decide to treat employees well for the purpose of greater productivity and higher levels of innovation. And for that purpose, there should be rewards and compensation for the employees so that there could be an impact on the emotions of workers. When employees see that a firm values their emotions as well as exhibits values such as honesty, respect, and trust, they feel less pressure, more valued as employees, more satisfied with their organizations, and ultimately these factors will increase the productivity and innovation. If the employer consider that issues, that would be considered as a utilitarian ethics because in that case the employers are focusing on the end results. And as well as this strategy can be compared as a corporate social responsibility because the employers are focusing on doing good for the employees. The second perspective on the ethics of workplace relationships is that employers might treat employees well out of a sense of duty and rights, regardless of the either utilitarian or self-centered productivity consequences. That means the first perspective was based on the utilitarian or self-interested to increase the productivity, and in the second perspective we can see employers may treat employees well for the sake of duty and rights. And this deontological means any belief on the basis of right and wrong. This deontological approach emphasizes the rights and duties of all employees and treating employees well simply because it is the right thing to do. And this sense of duty may arise from the law, professional codes of conduct, corporate codes of conduct, or such moral principles as fairness, justice or human rights on the part of the organization's leadership. This sense of duty or rights may arise from the following factors. In the second perspective, we can see employer might treat employees well because they think that it is the right thing to do and it is their duty. The parameters of the employment relationship. Employment implicates ethical issues because of the very nature of the relationship it implies. That means employment creates an ethical issues by which there will be a relationship between the employees and the employer. Consider the situation in which an individual agrees to work for another individual. This arrangement raises issues of power, obligation, responsibility, fair treatment and expectations. That means whenever there is a employment relationship, that type of issues arises. Power, obligations, responsibility, fair treatment, expectations. In many circumstances, the livelihoods of both parties means the employees and the employers, rely on each other's contribution to the relationship. That means both employees and employer are dependent on each other's contributions. Though legal requirements might serve to protect some interest, they can only go so far and cover so many bases. We will begin by looking to the ethics underlying the concepts of due process and fairness that help determine what is and is not acceptable behavior in the workplace. That means we will find out the acceptable behavior on the basis of due process and fairness. The relationship is defined by the application of the principles to working conditions such as health and safety, both in domestic operations and abroad. So whenever there is a employment relationship, the essential issues could be identified from the due process and fairness to maintain a good relationship which will contribute to the both parties. Concept of due process in the workplace. Due process indicates the right to be protected against the arbitrary use of authority. In legal context, due process means the procedures that police and courts must follow in exercising their authority over citizens. And in the context of employment, due process indicates the conditions for basic fairness within the scope of the employer's authority over its employees. That means in the context of employment, due process means the employer can exercise the power by following the fairness. Employment security, getting and keeping a job, is perhaps the most significant aspect of work from the employee's ethical perspective. Employers can tell employees what to do and when and how to do it. They can exercise such control or power because they retain the ability to discipline or fire an employee who does not comply with their authority. However, basic fairness implemented through due process demands that this power be used justly. Whenever you are exercising your power as an employer, you should follow due process, and that due process would be maintained if you follow the basic fairness. Employment at will and its ethical rationale. Employment at will means in the absence of a particular contractual or other legal obligation that specifies the length or conditions of employment, all employees are employed at will. That means if there is no particular contract or legal obligation in any employment, that employment should be considered as a employment at will. And if there is no agreement in context of employment at will, the employers are free to fire an employee at any time and for any reason. On the other hand, considering the employment at will, The worker may opt to leave a job at any time for any reason without offering any notice at all. That means by this employment at will, both the employers and employee enjoy the mutual freedom. Employers can fire the employee anytime for any reason, and employee can decide to leave the job anytime without offering any notice. And the ethical rationale for employment at will, both historically and among contemporary defenders, has both utilitarian and deontological elements. That means in this employment at will, there is a concept of utilitarian and deontological aspects. Employment at will provides freedom to both employers and employee. The cost of an employment at will environment. Even if employment at will proved to be an effective management tool, justice demands that such tools not be used to harm other people. That means, although this is a good aspects in employment, but this employment at will should not be used for harming others. Though the freedom to terminate the relationship is theoretically mutual, the employer is often responsible for the employee's livelihood. That means sometimes the more power is exercised by the employer, while the opposite is unlikely to be true. The differential creates an unbalanced power relationship between the two parties. That means under this employment at will, if any party exercise more power, then there will be a unbalanced power. Considerations such as this have led many courts and legislators to create exceptions to the employment at will rule. That means since there is a possibility of unbalanced power, that's why courts and legislatures have created some exceptions to the employment at will rule. Civil rights laws prohibit firing someone on the basis of membership in certain prohibited classes such as race, sex, disability, age, national origin, religion or ethnic background. That means on the basis of such aspects, one should not be fired, and that right is ensured by the civil rights. Labor laws prevent employers from firing someone for union activities. Employment at will has priority unless the employee can prove that his or her case falls under one of the exceptions. That means if there is an exception, in that case employment at will not be applied. But if the employee cannot show the proof of exceptions, in that case employment at will be applied. That means whenever there is exceptions, that exceptions should be proved by the employee. But if we consider the due process and just cause, in that case the burden to prove the exceptions depends on the employers. In that case the employers should show cause to justify the dismissal of an employee. Just cause means a standard for terminations or discipline that requires the employer to have sufficient and fair cause before reaching a decision against an employee. How due process relates to performance appraisals. Due process issues arise in other employment contexts as well. Employees are constantly supervised and evaluated in the workplace, and such benefits as salary, work conditions and promotions can also be used to motivate and sanction employees. Thus, being treated fairly in the workplace also involves fairness in such things as promotions, salary, benefits and so forth, because these decisions are typically made on the basis of performance appraisals. Due process rights should also extend to this aspect of the workplace. That means whenever we consider the performance appraisal for the purpose of promotions, salary, benefits, and other aspects, we should emphasize on the due process. And for that purpose, we should depend on the fairness. Is it possible to downsize in an ethical manner? Here the downsize means firing employees. Is it possible to fire employees in an ethical manner? People affected by the restructuring process must be treated with the same respect and interest that was shown when hiring them. Ethics must be central to the design and management of layoff policies. Yes, ethical manner can be followed when the employers firing employees. In that case, decisions regarding downsizing should be made by a representative group so that all stakeholder interests can be considered and to earn the trust of those who will be impacted. The facts should be collected and issues should be determined because employees should be kept aware of business conditions. The need for a downsizing effort should not come as a great surprise. So these are the ethical issues while doing downsizing or restructuring. That means there should be consideration and employer should earn the trust of the employee and the employee should be informed earlier. From a legal perspective, the decision about whom to include in a downsizing effort must be carefully planned, and that planning should be based on the some criterion. Firms should review both the fairness of the decision making process as well as the consequences of that process on those terminated and the resulting composition of the workforce. If the employer focus on the fairness and consider the consequences, then we can say that ethical manner has been followed in the process of downsizing or firing the employees. Difference between intrinsic and instrumental value in terms of health and safety. Health and safety are goods that are valued both as a means for attaining other valuable ends and as ends in themselves. That means health and safety is good for itself as well as if one employees are in health and safety condition, the employees can also attain other valuable ends. Whatever else we desire out of life, being healthy and safe makes it much more likely that we will be capable of attaining our goals. In this sense, health and safety have a very high instrumental value because part of their value derives from the fact that we use them to attain other things of value. That means if we have a healthy and safe position, we can attain other values and that values are considered as instrumental value. Yet health and safety are also valuable in and of themselves. That means whenever you are in healthy position, you are enjoying that good and this is considered as the intrinsic value. On the other hand, if you have a good health and if you are in safety position, you can attain other values which is known as instrumental value. The life of one who dies in a workplace accident has instrumental value that can be measured by the lost wages. But these lost wages do not measure the intrinsic value of the life. That means by the position of health and safety, you are enjoying something that is called intrinsic value. If you are in health and safety position, you can attain other valuable things that is considered as the instrumental value. Acceptable risk approach to health and safety in the workplace. Risk can be defined as the probability of harm and we determine relative risk by comparing the probabilities of harm involved in various activities. If it can be determined that the probability of harm involved in a specific work activity is equal or less than the probability of harm of some more common activity, then we can conclude that this activity faces an acceptable level of risk. From this perspective, a workplace is safe if the risks are acceptable. There is a figure from which we can easily understand about calculating acceptable level of risk. Here we can see if the probability of harm for any specific work activity is equal or less than the probability of harm for similar or more common activities, then it would be considered as a safe activity. On the other hand, if the probability of harm for any specific work activity is greater than the probability of harm for similar or more common activities, then the activity is not safe. If the workplace were less risky than other common activities, management could be conclude that they have fulfilled their responsibility to provide a healthy and safe workplace. But there are some challenges to maintain acceptable risks. The challenges are whenever you are treating employees disrespectfully by ignoring their input as stakeholders. Whenever you are ignoring the fundamental deontological right an employee might have to a safe and healthy working environment. Assuming an equivalency between workplace risk and other types of risk when there are significant differences between them. Improperly places incentives because the risk faced at work could be controlled by others who might stand to benefit by not reducing them. So these are the some challenges for maintaining acceptable risk in the workplace. Nature of an employer's responsibility with regard to employee health and safety. Individual bargaining between the employers and employee could be an approach to workplace health and safety. Employees would balance their preferences for risk against their demand for wages and decide how much risk they are willing to take for various wages. The preference could be if they prefer higher safety, they should accept the lower wages. On the other hand, if they prefer higher risk, then they could expect higher wages. In a competitive and free labor market, such as individual bargaining would result in the optimal distribution of safety and income. Of course, the market approach can also support compensation to injured workers when it can be shown that employers were responsible for causing the harms. As for example, an employer who fails to install firefighting equipment in the workplace can be held liable for burns an employee suffers during a workplace fire. The threat of compensation also acts as an incentive for employers to maintain a reasonably safe and healthy workplace. That means employers has a responsibility to maintain healthy and safe workplace. Otherwise, if there is any injury to any employees, in that case the compensation should be paid by the employers. That's why employer has a responsibility to maintain health and safety in the workplace. Why the market is not the most effective arbiter of the employer's responsibility with regard to employee health and safety. Here the market means a situation in which there is a bargaining power exercised by the employer and employee, but sometimes the market is not effective to maintain a responsibility of employers in maintaining the health and safety in the workplace, because the free market approach has a number of serious problems. First, labor markets are not perfectly competitive and free. Employees do not have the kinds of free choices. Secondly, we can say employees seldom possess the kind of complete information that is required by the efficient market. That means sometimes the employees don't have the information about the riskiness of the job, and markets sacrifice the first generation in order to gain information about the safety and health risk. As for example, we learned that workplace exposure to asbestos or cotton dust is dangerous when workers subsequently die from Lyme's disease. That means we may lose one generation to gain information about the riskiness. Another thing is that we ignore important questions of social justice and public policy if we approach questions solely from the point of view of an individual. So these are the problems for which employers' responsibility cannot be ensured to maintain the health and safety in the workplace. Diversity in the workplace. Diversity refers to the presence of differing cultures, languages, ethnicities, races, affinity or orientations, genders, religious sects, abilities, social classes, ages, and national origins of the individual in a firm. And whenever there is a diversity, the stakeholders in the workplace should focus on the values of respect, tolerance, inclusion, and acceptance. Benefits and challenges of diversity for the workplace. When there is a diversity, there will be benefits or conflicts in the workplace. The benefits of diversity can be as the followings: increased productivity and profits, improved creativity, improved company reputation, wide range of skills, improves cultural insights. So these are the benefits which can be achieved by cultural diversity. On the other hand, due to diversity, there are some challenges arises from the tension and anxiety. And tension and anxiety arises due to cultural challenges. And whenever there will be a cultural challenges, there may be conflicts between the stakeholders in a workplace. That's why diversity in the workplace can bring challenges or conflicts due to the fundamental differences in the values. As employers or the stakeholders should balance between the fundamental differences to maintain a good relationships in the workplace. Affirmative action. The term affirmative action refers to a policy or a program that tries to respond to instances of past discrimination by implementing proactive measures to ensure a equal opportunity today. That means whenever you are trying to ensure an equal opportunity by considering the past discrimination, that type of process is called affirmative action. It may take the form of intentional inclusion of previously excluded groups in employment, education, or other environments. But the use of affirmative action policies in both business and universities has been controversial for decades. 3 ways in which affirmative action may be legally permissible. Affirmative actions arises in the workplace in 3 ways. The first way is whenever there is a legal requirements, and the second way is whenever there is a judicial affirmative action, and in the third way is whenever there is a voluntary affirmative action plans from the employers. In that case, there should be training plans and programs, focused recruiting activity, or the elimination of discrimination that might be caused by hiring criteria that exclude a particular group. In this chapter or in this tutorial, the main focus is on the employment relationship. In maintaining a good employment relationship, both the parties should follow due process and fairness. On the other hand, another issue is health and safety in the workplace. In that case, by maintaining health and safety in the workplace, both the employers and the employees can be benefited. Thank you.